Welcome to the Board of Pharmacy, both of you in the audience. This is going to be a very personal committee meeting for you. This is a committee meeting for the Licensing Committee report, or Licensing Committee, and let me start off by letting everybody know that this is being webcasted. And secondly, why don't we introduce ourselves and do roll call?
Victor Law, professional member.
And I'm Debbie Veal, professional member.
Albert Wong, professional member.
Stan Weiser, professional member.
Ricardo Sanchez, public member.
Lavanza Butler, professional member.
Okay, and with that, I'm going to go ahead and dive into our agenda, with agenda item number 1 being the status of implementation of recently enacted legislation impacting licensing programs for the board. And the first item we're going to address is Assembly Bill 2605, Bonilla, Chapter 507, Statutes of 2014, regarding the third-party logistic providers. So if you've attended the licensing committee in the past, you know that we've walked through this legislation. And AB 206 was the board-sponsored legislation to ensure the appropriate and continued regulation over the third-party logistics providers, also known as TPLs. Specifically, the measure created 3 new licensing categories for the board, as well as established the requirements for the application, licensure, and renewal of these categories. The new classifications are third-party logistic provider, non-resident third-party logistics providers, and designated representatives, 3PL. In the past, during the January board meeting, members were advised that the freeze exemption was approved and the board staff is working with the department to identify the necessary programming requirements in order to implement this statute. At that time, the department estimated the programming changes would be completed by April 1st, 2015. And the draft applications and instructions have been submitted to legal review in December. So the most recent update is, unfortunately, delays in finalizing the business requirements. The programming necessary to fulfill the implementation of this program has been delayed without an estimated date from the department, but they do continue to work on the project. Most recently, staff started testing in one of the legacy environments and is working with the department to identify any changes. Board staff posted the approved application in early February on the board website and sent out a subscriber alert advising that the applications were available. It was also noted in the recent issue of the script, and in addition, the staff has developed a guidance document to highlight the steps the licensees and applicants must take to secure compliance with the new law. Board staff has developed a temporary workaround solution to issue licenses. The first licenses were issued in February, but we have not received the volume of applications we had expected based on the inquiries we received during this process. So attachment 1 to your to the board packet is the guidance that the board staff has developed. And hopefully you have had a chance, anybody who has any questions about this process has had a chance to look at it. It details what needs to be put on the application, kind of pointing out specific areas of concern or where there might be some questions. So with that, let me ask if are you leaning towards the mic? Was there something you wanted to say?
I'm just in the ready position.
Okay. Are there any questions or comments of the board members?
Kenny, who authored this? Was it you?
Authored what, the bill?
Guidance?
The
Or
guidance
bill?
Guidance.
It was a combination. I drafted part of it, and then Ann came in behind and made a couple changes behind it.
I had a little trouble.
Following it?
Ann did the whole thing.
Blame it on Ann.
But what did
Basically,
you-
let me explain what the guidance is for. We believe a number of 3PLs are currently licensed with us as wholesalers. So what we wanted to do was to streamline the application process where we would take existing items that were already in the wholesaler file and use that to kind of help them become a 3PL so that they wouldn't have to go through some of the reprinting, some of the other things that we do to everybody as a new applicant. Because basically, up until a year and a half ago, they were licensed with us as wholesalers. So that's kind of what the whole guidance was. And we developed the guidance after we had a chat with the association that represents 3PLs, so that we were trying to make it easier for them. Now, if it doesn't make sense to you, it may not be easier for them either, so.
I don't know, did anybody else have an issue with the flow of it?
You know, probably because I've been through all the meetings and I kind of realized what happened, I guess maybe not, but so that puts me at a disadvantage. So I think maybe making the assumption that the 3PLs who went through the wholesaler process in the past, that this makes sense to them, I mean, that might not be the right assumption. So I think if you have suggestions, then why don't you?
I mean, like under the designated representative, the first bullet, all currently licensed, California licensed designated representative.
You might want to speak into the mic because I really can't hear you.
Okay. Anyway, well, that first bullet I had some trouble with, I think.
Well, the issue is currently they're licensed as designated reps. But for a 3PL, they can't be a designated rep. They need a special license called a designated representative dash 3PL.
Okay. Okay.
Because the 3PLs wanted a separate set of qualifications. They're markedly similar to what they have to have as a designated rep.
Okay.
But for a 3PL, they're actually a little less than they are. So anyone that qualifies as a designated rep for a wholesaler would immediately qualify for licensure as a 3PL designated rep.
Okay,
So
cool.
we're just trying to subsume them in there without having them go through a big lot of rigmarole.
And I think actually the 3PLs, that would make sense, because I think that was one of the things that they testified that they felt was that they didn't think that their designated representative needed the same criteria as the wholesaler.
Okay.
And what qualifications do they need to be a designated rep for the 3PLs? Do they need to be 18 years old,
Yes.
another year of experience in a pharmacy-related field?
In a year doing drug distribution.
Okay. And does each 3PLs require one designated representative, or they could have more than one?
They always have to, whenever they're operating, they have to have at least one
One
present.
present.
Whether they're in-state or out-of-state, and then they have to have a responsible manager in charge of the facility that may or may not be there, but that would be someone who we would hold responsible if something went wrong in the facility, as well as a designated rep. And that person has to be a designated rep 3PL too.
And also, currently, we have about 600 wholesalers licensed in the state of California. So do we anticipate most of them roll over to the 3PLs? Or where are the new 3PLs going to come in from?
It's hard to tell. A lot of the 3PLs are already part of wholesalers, but drug manufacturers are kind of leaning towards using a 3PL structure to distribute, because that way the drug manufacturer still owns the product. They can see exactly what drugs they still have in the drug supply, which they don't know if a wholesaler has bought them. So it gives them better control over their manufacturing side and production, so they know what's already still not been dispensed. Otherwise, they just know that they've sold the drug to a wholesaler and they don't know where it is. They don't know if it's been dispensed, if it's sitting in storage somewhere or whatever, because it's no longer their product.
But so far, we only have a few applications
We have only a
coming
few.
in, right?
They think that they don't have to be licensed. We may have to start making a point of this.
Okay, got it.
This came out of federal.
This was federal, the federal legislation required them to, they established a term, you're deemed a license whether or not anybody does anything, unless the state acts. In our case, the state acted, because we're the only ones that have done this so far. Florida licensed them separately for years, but we're the first state to have done the 3PL. At NEBP in May, I've been asked to speak about what we're doing with the 3PLs because we're the first ones out there.
Thank you, Stan, for bringing that up. Let us discuss it. Is there any other questions about the document?
Something going on down there.
Public member.
Ann or nothing?
Any other? Public, any comment? I don't see any 3PLs out in the audience, so
They're watching.
hopefully you're watching, Mr. 3PLs, and please note that you do need to be licensed.
Please.
Please, pretty please. Okay, moving on.
$5,000 an invoice. Maybe I should say that.
Yeah, so there's a stiff fine. We would prefer not to apply. Okay, I'm moving on to agenda item, or I'm sorry, still agenda item 1, but now I'm talking about statute SB 1159 by Laura, which is a professions and vocations license application individual tax identification statute. This legislation required the board on or before January 1st, 2016 to accept either a Social Security number or an individual tax identification number as a condition of licensure. Prior to this legislation, the board could only collect a Social Security number. So the recent update is the board staff has undertaken revisions to several of the application forms and instructions. Further, as the pharmacy technician application is incorporated by reference and regulation, implementation of this update needs to occur through regulation. The formal rulemaking process was initiated on February 20th, 2015, and runs through April 6, 2015. Absence of any negative comments, the rulemaking will be brought back to the board at the April board meeting for final adoption. Board staff does not anticipate any challenges with the meeting of the January 1st, 2016 legislative mandate. Staff anticipates that all other application forms will be completed by the end of April 2015. In addition, we are evaluating additional changes that may be needed to be made to facilitate full implementation for pharmacist examination administration. This review should be completed no later than June 30th, 2015, and an update provided during the July board meeting. Are there any comments by the board members? Questions, thoughts, staff, public? Okay. Number SB 1226, Veterans Professional Licensing as background. This requires the board on or before July 1st, 2016 to expedite the initial licensure process for an applicant who supplies satisfactory evidence to the board that the applicant has served as an active duty member of the armed forces and was honorably discharged. Implementation of this provision will require updating the application and instruction forms. The legislation has to take effect on July 2016, so implementation efforts are not yet underway. The Department of Consumer Affairs has advised all boards and bureaus within the department that no modifications will be made to the legacy computer system. As such, any implementation efforts necessary would require manual workarounds by the board to implement. So I guess, are we kind of waiting to see if perhaps the new system is in place and so manual workarounds will not be required, or is it inevitable probably that a manual workaround is going to be required?
There's kind of a common theme that you perhaps
Yes.
heard with the 3PLs, that we're kind of on our own here. This is, again, we're kind of on our own. There is a finite number of staff available to program in these changes, and they're not using them for these kinds of things. So
So we're going to probably end up with a manual workaround.
I was going to let Ann respond to that. She looks like she's ready to respond, so.
You can turn on your mic and respond. We would be so appreciative.
We do anticipate some manual intervention.
Thank you for that validation. Yes.
Walking the halls of the Capitol yesterday, did I hear correctly that the state has reinitiated its relationship with the Breeze people, and that they've found more funding for the Breeze program with the past vendor?
They authorize additional money to help bring, I think it's phase 1 and 2, up to where they should be, because the system as it was implemented requires intervention by programmers in order to keep it current. So an example would be this. You would have to rebuild your whole system in order to do this, which costs money. I don't think that there's too much money in Phase 3 development, which is where we're going to be now. It's all pretty much aimed at Part 1 or Phase 1 rollout, which they went live almost now, a year and a half almost ago. And then Phase 2, which is going to supposedly come up, I believe the date now is December. And we're just waiting. We don't know where we are in the queue. The department, I think we can figure, will ultimately end up putting us all into Breeze because the department, I don't think, can withstand two separate systems like we have now. But we don't know what that's going to look like because they're looking for some fundamental changes in the Breeze system and in the vendor.
So does it look like the original vendor will continue on as the vendor?
I don't have any way of knowing that. I don't think anyone knows that yet.
And also, when they meant to expedite, is there a time reference that this measure requires?
The department is very sensitive to the various bills, and there's probably been 4 or 5 of them, maybe 6 or 7 of them, to help facilitate the licensure, at least in California, of vets or people that are serving the country. And so there's been a whole series of these over the last 2 to 3 years. Expedite the applications, if you're a spouse or a significant other, expedite them, that kind of thing. I think at this level, it's pretty easy for us to manage. I think for some boards, it might be harder to do it if you have to do it manually. But at the end of the day, something's going to have to happen because ongoing, there are certain things that they want. One of the things they're building into the licensing systems for both the legacy and the Breeze systems is a way to identify at the time of renewal if you're actively serving in the military. And that is a very expensive modification because it goes on to the renewal notices, which means that everybody's stuff changes. So did I forget something, or is there anything you want to add?
Yeah, we currently expedite military spouses, and it is a manual process. The manual process of the application itself is not where the challenge is. The challenge is managing it so that we have reliable statistics to demonstrate the number, the volume that we receive and the workload. That's where the workaround solutions primarily come from.
How do you identify the spouse?
So we have on the application a question, and then we tell them what we need to substantiate that. And it's on, right now, it's just on the face of the application. So even as the mail is coming in and being opened, they're separated out so that they do get processed first.
Even before we get the check off, we're looking for that.
And do we currently have a lot of these licensees under these categories, or just
No.
a few?
Yeah, I don't think that we receive a significant volume.
Some boards actually do have a lot, we don't.
Any comment from the public?
I'm going to put you all up here so we can see you
I think we ought to ask them their names and so we can call them by name.
You already know most of their names.
We're not trying to embarrass anybody, it's just that it's such a small group of you. We'd like you to feel welcome and part of this.
They should get extra credit.
Yes. Okay, moving on to SB 1466, Business and Professions. This legislation contains 2 provisions that impact the board licensing program. The first amends the definition of a correctional facility. Implementation of this provision will require updating the application and instruction forms as well as securing changes to the existing licensing application system. So I think just as we've been kind of discussing, we will secure a freeze exemption, and the staff will work with the department to make sure the necessary changes are implemented when.
A couple of years from now.
Yeah. SB 1466 also changes the requirements for an applicant. Designated representatives require that the individual be at least 18 years of age, and this provision only requires a procedural update. The board staff has, so the most recent update on SB 1466 is the board staff has initiated implementation efforts, including creation of a new application form for the licensed correctional facility license category, as well as revision of the designated representative application form. Board staff is preparing the freeze exemption request as a first step to implement the necessary changes in our legacy system. The changes to the designated application is currently under review and should be finalized in the next few weeks.
So what is the rationale behind the new definition as opposed to what we had before?
Go ahead, Ann. I've been talking too much. It's time to share.
So the licensed correctional facilities has always been kind of its own little thing. The changes in the law from last year expanded the licensed correctional facilities to be both government-owned as well as privately owned. And so that was the major change there. So our current structure was set up that basic things like it was all fee exempt, and we didn't collect the same amount of information because it was government-owned. So as we're transitioning to prepare for those that are possibly privately owned, there's a lot of work that we need to do to evaluate whether or not we require the same level of information and what that should be, as well as getting the necessary programming changes in place so that we can do basic things, even like process of payment.
But there's a whole series of regulations ultimately that we will probably work with the Department of Corrections to facilitate, because a prison pharmacy doesn't really operate. It's close to an inpatient pharmacy, but not quite the same. And right now we kind of regulate them as a hybrid, but we don't really have any specific criteria specific for them. And one of the things that when supervising Inspector Bob Ratcliffe was here, one of the things over the years that he was really interested in was dealing with this specific component. But he retired before we got that completed. So we've got the requirements. There's some interest. Periodically we hear former board member Randy Kajioka is now running the Department of Corrections pharmacy systems, and he periodically kind of brings up, hey, what are we doing here? And we're just not ready to take on another program of this magnitude yet. We're trying to work with some existing regs and the drug take-back provisions. Once we get through with those, I think that this is probably one of the looming issues. It's just right now it's a contained program. And we're going to need a lot of public input, specifically from the correctional facilities, because they have their own way of doing things. A lot of them are starting to use vending machines now, or dispensing machines, because and it provides them with a real solid means to control the inventory, so people don't just take advantage, because you don't know who necessarily is getting access. And I don't mean the inmates there, but so anyway, so we need to empower the machines, and we can't. That's another issue, and that'll probably be one of our sunset issues, frankly, is how are we regulating these machines? Because right now we don't even know where they are. We don't know who's got them, who's stocking them, where they're located, and we think that if pharmacies are responsible and control machines, we need to know which pharmacies are controlling which machines. Nothing more than, just a list maybe. But
So do you, what do we do with the machines? Because I know, like in hospitals, sometimes they use machines.
don't know where they are. We
Okay.
walk in and
so
we
it's
ask.
not just, it's just not the.
Oh, no, it's
correctional
all
facilities.
environments, skilled
Okay.
nursing facilities in particular.
Yeah, they're really big on them.
Yeah. The bigger the skilled nursing facility, the more machines they're likely to have.
Yeah.
Yeah.
Any other comments by board members? Public? Okay, hearing none, I'm going to move on to agenda item number 2, which is Department of Education acceptance of additional tests for fulfillment of the General Education Development Certification Equivalency. Our B&P Code Section 4202 establishes the requirement for licensure of a pharmacy technician to include the provision that the applicant either be a high school graduate or possess a General Education Development Certificate equivalent. The board staff recently was advised that the Department of Education has recently approved 2 additional exams that would satisfy our requirement. The 3 exams are the GED, or the General Education Development Test, which I think is what we've been used to in the past, and the 2 new ones are HISECT, which is the High School Equivalency Test, and I'm just going to say the initials because I'm not sure what their acronym really is. TASC. I'm guessing they maybe call it TASC, but I don't know. Test Accessing Secondary Completion. Board staff is in the process of updating the instruction sheet to incorporate the references to these additional exams. Are there any other comments from the board members on this? This is kind of a more for information situation. Public. Hearing none, I'm going to move on to agenda item number 3, which is the status of the board-sponsored legislation to change the documentation request for pharmacy practice experience, which is SB 590 Stone, Senator Stone. During October 2014 meeting, the board voted to pursue a legislative change to streamline the documentation requirement for pharmacist practice experience for students that graduate after January 1st, 2016 from an ACPE School of Pharmacy or a School of Pharmacy recognized by the board. Senator Jeff Stone is authoring this bill for the board. The provisions are contained in SB 590, which was introduced on February 26, 2015. Board received concerns from the California Pharmacy Council, which is a group of California schools of pharmacies associations, as well as the board's executive officer, regarding the language contained in the bill. Based on these discussions, staff has requested that clarifying language be amended to the bill to address the comments from the CPC. So if you look at attachment 2, you'll see the draft version with the proposed amendments. I don't know, Ann, do you want to just kind of go over generally what, or Jenny?
No, Ann can do it.
And,
this is her baby.
do you want to go over generally what the concerns were, and so we can kind of understand the, I mean, it looks like it was just kind of more wording, like interns and pharmacies and pharmacists, but can you just kind of go over this for us?
So if you look at attachment 2, the proposed amendments are identified through double strike through and double underline. And so some of it is technical in nature. We used the word approved. They're actually accredited schools, so we changed it from approved to accredited. There are no departments of pharmacy, so we removed the word department and changed it to school of pharmacy. And then we clarified that it's not just the 1,500 hours of experience that was being satisfied, but it's the 1,500 hours. They're consistent with the ACPE requirements, and it includes the community and institutional. So that's what the last part is, where it says the pharmacy practice experience specified in subdivisions A and B. So we've just clarified that they don't have to do any of it if they've graduated from the School of Pharmacy that's either accredited by ACPE or a school recognized by the board. And then procedurally, as we've discussed previously, we will be accepting the transcripts with the degree posted and the date conferred as proof that they have satisfied the intern hours requirement.
So there's also changes in blue and strikeout in red.
So that was as the bill was initially introduced. I don't have a color copy, but that's what
Okay.
the bill was as it was initially introduced.
So that was the changes that Senator Stone's bill makes to 4209.
In its current form,
Okay.
and,
And
then
then
the
you- and then
double is what we'll be amending into the bill.
So it's really, it looks like the changes really were just on section D.
Yes.
The bill was up yesterday in the Senate B&P committee, and it was on consent, which is a good thing.
Okay.
So, no testimony required.
And I think this, this committee was kind of one of the advocates behind this bill.
Yes, I think you probably remember about a year ago, we were doing some serious talking about this.
I have a couple of questions. Would this be the appropriate time to ask?
We would welcome questions from from the board members.
Thank you. So
Albert?
an intern pharmacist must have experience as a pharmacist. So is that a little bit of a contradiction, or do we accept? I mean,
What do you, can you point what you're referencing?
okay, item number 4209, 3 in blue. So we're talking about an intern pharmacist shall complete if we go up to 4209A1. Now we're at 4209. So we established the fact that the person doing this is an intern.
Right.
And then in 3, it says that the pharmacy practice experience shall include 900 hours as a pharmacy practice experience in a pharmacy as a pharmacist. So is that wording okay?
There's another provision that indicates that a pharmacist can do, or an intern can do anything that a pharmacist can do. It just needs to be under the supervision of a pharmacist. So I'm sorry, I should have included that. We're not amending that other section, but there's another statute that specifies that the experience
Okay.
has to be earned under the supervision of a pharmacist.
Okay, and then further down under C, so we're talking about a pharmacist in C who's licensed in another state for at least a year. And so here I am in Connecticut, and I've been a community pharmacist since graduation. And I want to come to California and work as a pharmacist. So after the words 900 hours of pharmacy practice experience in a pharmacy as a pharmacist, and has pharmacy practice experience in both a community and an institutional pharmacy practice setting. So what is an institutional pharmacy?
Would that be
hospital?
That would be a hospital.
Okay, so if I have always been working as a community pharmacist and never went from school into an institution and just went right into retail, would I be eligible? Would that condition as an institutional pharmacist as well, practice?
ACPE insists that you would not graduate from a school of pharmacy without having some institutional experience.
Right.
So as part of your education, you'd have that. You wouldn't necessarily have it as a practicing pharmacist.
Right.
You would have had it as part of your training to become a pharmacist in a school of pharmacy.
So our point there is we're trying to make sure that your college education, even if you came from Connecticut, would be similar to a pharmacist
Actually
from,
got dial phones now?
would be, I mean, that your educational experience would be the same from Connecticut as California, as Iowa, as any other state.
And that is also, those provisions are also
Okay, I'm okay with that. If
well,
that's the
those
intent.
provisions are also
you
in
understand.
law. They currently reside in regulations, so we've moved it to the statute so that you are looking in one place to see that. So that's existing law.
Okay. Thank you.
Is that it?
Yeah.
Any other questions from other board members?
Only on that 4209 number 3, when it says you need 900 hours of pharmacy practice experience in the pharmacy as a pharmacist, and then it said it shall include both community and institutional practice. But it doesn't specify any hours either way, or does that mean that your 900 is a combined total of both?
900 is combined of community and hospital, which is, once again, that's in line with what ACPE told us.
Okay. I thought it was just kind of redundant when they said this sentence. They could have just said that you include the 900 hours of pharmacists in both community and institutional setting. Instead of adding another sentence, it said it shall include the pharmacy practice experience again. It's kind of redundant.
I think it was belt and suspenders where we just wanted to make sure it was all. But, so what would you expect to see instead?
After, as a pharmacist, you could say in both community and institutional practice setting.
It's a duplicative of pharmacy practice experience, using that kind of twice.
Yeah, you count
You
3
could just-
times actually. If you
yeah.
read that sentence, you got pharmacy practice experience 3 times.
Yeah.
So the requirements in the regulation currently are you need to have 1,500 hours of experience. In addition to the 1,500 hours of experience, you need to have 900 in a retail setting, in a community setting.
Right.
In addition, you have to have experience in both the institutional and the community. So what that language is designed to do is, again, take what's currently in regulation and put it for the out-of-state, which is currently the requirement, but consolidate it into here to meet all 3 of the requirements for the experience, which is the 1,500 hours, 900 that has to be in community, but that you also have to have some type of experience in institutional.
Yeah, I get what you mean, but I thought kind of was written.
Or institutional, yeah.
as I'm trying to understand too, so that experience in school would count for those community pharmacists. Okay.
Part of what was presented to this committee specifically by the ACPE and the school deans was the practice of the pharmacy experience that they get while they're going to school is so integrated in the curriculum that specific hours in an internship in a pharmacy is no longer really necessary, is what they frankly said. That it's so fully ingrained that they're getting the experience through a variety of ways. Whereas before, part of the problem is that some students would have to wait months after graduation to get the pharmacy experience they needed in order to qualify, of the 1,500 hours in order to qualify to take the exam.
Well, actually, on some of these ACPE new standards that came out, they already require 400 hours of the IPPE and 1,420 of hours of APPE, which have already exceeded that
1740.
1740, and it would exceed the 1,500 hours. And they also required that you have to have certain blocks in community and certain blocks in institutional. So if they have finished the ACPE require accredited program, they actually have met this requirement period.
Wasn't too long ago that a seasoned pharmacist was...
Who happened to have been president of the board, maybe?
No.
Okay.
A seasoned pharmacist had a disciplinary issue, and one of the conditions was that this pharmacist, in order to become licensed again, had to take the exam again. And it was interesting to see that, again, this seasoned pharmacist who probably took the exam maybe 40, 50 years ago first, was able to achieve success and pass the exam. So I'm getting back to this seasoned pharmacist issue in another state coming here. So are we saying that if you do not have the experience in a institutional facility, you would not be eligible to come here and take the exam? Again, I mean, would that mean that I couldn't take the exam today?
What the section is designed to do is say that if you've been licensed for 1 year in another jurisdiction, we're going to accept the proof of your experience in a different format. And that different format is license verification from the state board in which you're licensed. And so we accept that as the proof that you have met the intern hours requirements. With respect to the community and institutional piece, it is a self-certification question on the application that indicates that you have experience in both the community and the institutional setting. It does not have to be experience as a pharmacist. So as part of your education, which I believe generally the education includes exposure to the institutional setting as part of the curriculum, you would satisfy the requirement and self-certify that you've met the requirements.
Yeah, but my question is that there was a point in time when schools didn't have the institutional component for graduation as a pharmacist eligible to take an exam. Now, it was long before you were born, but that did exist. And as I look around and we speak to pharmacists who have been licensed for 50 years and continue to work and be productive and be active in the profession, if somebody came here that didn't have that institutional, wanted to take the exam and could pass the exam, would they be eligible to take it?
If you actually read, it says, an applicant for the examination who has been licensed as a pharmacist in any state for at least 1 year, as certified by the licensing agency of that state. So what they get from that state may submit this, so the license from the other state, as certification to satisfy the 1,500 hours, blah, 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 blah. So the license, and if I'm stating this wrong, please correct me, Ann, as I know you will. But so you've been a pharmacist for a year in another state, you can use that to satisfy the 1,500 hours.
Right.
And this is,
So
again,
what, and it doesn't say we're going to go dig into, it's just saying that satisfies your 1,500 hours. And then it kind of explains what the 1,500 hours is again. But they're not going to go check and see if when you were a pharmacy student, what your 1,500 hours were. You've met that qualification because you were a practicing pharmacist in another state for a year.
and this is, again, it's existing law. So even if we removed it from here, it would still be in regulation and would be existing law. We're just trying to put it all in one location so the regulated public doesn't have to search several areas.
So you basically get a card out of jail because you've been practicing in another state for a year.
Provided provided that, it must be they, satisfied requirement 1,500 pharmacy practice experience, yeah. And provided that the applicant has obtained a minimum of 900 hours as pharmacy practice experience in a pharmacy as a pharmacist, and has pharmacy practice experience in both a community and institutional pharmacy practice setting.
So it's just saying all the things that the license, isn't even the last, certification of the applicant's license in another state shall be submitted in writing and signed. So that certification meets what, the 1,500 hours, which is 900 hours of pharmacists in a community and institution.
Okay, so I'm misreading it, and I'm okay if I'm misreading it. It
It
But
says.
it seems to be exclusive.
It says in any state.
It's intended to be inclusive, not exclusive.
Okay.
And your experience in your particular case with skilled nursing facilities would apply, I believe, towards institutional settings,
Okay.
because your experience there has treated you to deal with patients in a community environment where they're cared for under a medical institution.
But if I didn't have that, it would be exclusive.
Well, we have required, as Ann's saying, that our law, for 25 years, we've required them to have experience in both
Okay,
settings.
okay.
And they certify it. We don't go looking for it. We believe, we were told, and I think the deans insisted when they were going through it, and certainly ACPE did, that you cannot get through a program without having a sampling of various kinds of institutions. So, for example, those of you that are pharmacists on here, think back to when you were in school. Did you not get some experience institutionally?
Hospital
I'm-
rotation.
I'm fine. It just looks like new language to me. So if it's existing, oh, that's fine. I'm fine with that.
Yeah,
If
when
it-
we
if
go
it-
through pharmacy
I think
school,
you're
we have
reading
to
it
go
properly.
through the hospital rotation and community rotation. So we get those experience through school.
Yeah, but I'm talking about, some guy coming from West Virginia to get Connecticut.
Now we'll get the calls now.
I'm gonna
Okay.
go all the way
Leave it
down
at
to-
Connecticut.
I'm going all the way down the eastern seaboard.
Provisions are currently in Regulation 1728.
And have
Okay.
been there for quite a while.
I'm good.
No, we understand, I think we understand, and you're right, that is exactly what it says. And so they are attesting when they come in and they sign that affidavit that they do have experience. Oh, come on, you've got to hear me. I can hear my voice echoing. They do have to attest that they have experience in both, but there is no set hours for either. So it's conceivable you could have somebody with all the experience in an institution and zero in community, I suppose.
Yeah, yeah.
Although, again, we've been informed that that isn't going to happen. But
Okay, thank you. I apologize for taking the time of the committee.
So, and with the corrections in blue, would that satisfy all the concerns of the other school of pharmacy personnel?
It's actually the double underscored correction.
Okay, so,
Yeah,
Down-
so
it's
with
basically
the
down in
Pharmacy
D. That's
Council, is that
Right.
what you're referring to?
Yes, yes.
And they have seen this language.
okay,
Yeah.
all right. So we're good.
Is there any comments from the public?
oh, come on. We'll see if it's interesting.
I just have a question.
So just say your name for the,
Satinder Sandhu, I'm with Walgreens, but I just have a question as a pharmacist. I have a question. So the 1-year requirement, if, let's say, a student who just graduated from school outside of California and they got licensed in the state, they practiced for 2 months, they moved to California, Now, they have not practiced 1 year in that particular state, so you would not accept their experience because they're not
Well, we
practiced
would,
there.
so then
In
it would
which
go
case-
back
but-
to their college.
So you go back to their college
As long
and
as
they
they're
would be able to be
ACP.
licensed?
We're going to put you to work.
Hours earned in another state can be verified
exactly.
that state by that state board. So if they earned their experience in Idaho, the Idaho State Board of Pharmacy could verify their intern hours to us. There are some state boards that do not verify intern hours, and if that's the case, then they will have to find their preceptors and have them verify their intern hours on our form.
I understand that, but if the requirement is that they get enough hours going to the school, and they're no longer, you still require the preceptor hours?
If they have less than a year of experience as a licensed pharmacist in another state, yes, we will still go back and
But-
look at their schooling.
If they went to school in California, then you would not require the preceptor to certify those hours. You would accept the schools.
Right, that's one
So-
of the things this removes.
Yeah, so what this bill would do is for any graduate from an ACPE accredited school of pharmacy, it does not mean that they had to go to school in California. If they graduate after January 1st, 2016, from an ACPE accredited school of pharmacy or a school of pharmacy recognized by the board, their graduation with their degree posted and their date conferred will satisfy the intern experience requirements.
So it would not require the preceptor in those scenarios? Okay, that's,
Yeah, so look, that's what section D that's being added, that's what that clarifies.
Pretty much all the schools in the U.S. are ACPE accredited school of pharmacy, so unless they graduate from out of the country.
Thank you.
Well, there's
Secretary.
actually one outside the country.
Yeah, because I
Lebanon.
think, yeah.
There's one in Lebanon.
Thank you, Satender. Is there any other questions, comments from the public? Okay.
Oh, so Jeannie, so what happened now to the bill? It moved through the Senate? Did it go through the Senate?
It still will have, I think, a brief review by the Appropriations Committee, then the floor of the Senate, then it'll go into the Assembly.
Okay.
But it doesn't hurt to start out with a consent assignment in your first policy committee. That's a nice way to start off.
Okay, I'm going to move on to agenda item 4, NAPLEX exam content outline update. So the NABP recently completed its process to ensure its exam includes the most current standards for safe and effective pharmacy practice. As a result, the NABP has released its new competency standard statements, which go into effect on November 1st, 2015. This revised competency statement will be evaluated by the board's Competency Committee as part of its work to evaluate the board's current content outline for our own CPJE, or the California Practice Standards and Jurisprudence exam. And I guess if, in looking at that statement, if they see that maybe NABP is taking out something that we think is important, then they may revise the competency statement for our CPJE.
Right, there's a very detailed review that goes on by the members of the Competency Committee that compare the duty statements, the task statements here for the NAPLEX, that they then compare on the basis of what's left in the California outline, what was changed, and what resulted from the job analysis that we conducted about 6 months ago. And so if it's on the job analysis that comes in as a frequent or highly important task, NABP is no longer testing it, we'll test it.
So if you want to see the revised competency statement by NABP, it's in attachment 3.
Relatively short.
Yeah, it's only like a couple pages
Very
long.
succinct. I think ours is considerably longer, even though that's small font.
Are there any comments by the board members? Any public comment? Not hearing any, I'm going to move on to agenda item 5, which is the Competency Committee report. Effective February 26, 2015, the board instituted a quality assurance review of the California Practice Standards and Jurisprudence exam for pharmacists, fondly known as CPJE. This means that there is currently a delay in the release of all CPJE exam scores. The process is done periodically to ensure the reliability of the exam. We hope that by May of 2015, we will be able to release scores more quickly as long as the review is completed. So, as we always say, if you are thinking about taking the test, don't wait until after May, because you're just going to slow down the process. Just get in there and take it. You can be another person that is part of the review, and it causes the review to end quicker. The Competency Committee work groups are meeting several times this year to continue examination development activities. And in addition, they will review the revised NAPLEX content outline as we just discussed. It is anticipated that a recommended revised content outline will be ready for board review and consideration during the October 2015 board meeting. So once our Competency Committee reviews what NAPLEX did or NABP did, then they'll probably come back to us with some suggestions, and we'll see that hopefully in October. So mark your
hopefully.
calendars. Are there any comments or thoughts by board members on?
Yeah, I'm on that committee. Actually, we are meeting a few times this year with a new set of guidelines from MEBP, and then we match up with what they are supposed to do. So it's a lot of work for the committee. Overwork, underpaid.
But they get credit.
They get
Not
CE.
yet. Not yet. The reg's still been pending for like 4 years probably.
Oh, really? I didn't realize
Yeah,
that.
no, they're just getting paid. It's an
Not
unfair.
much.
And not much.
Public, do you have any comments? Okay, hearing none, I'm going to move on to agenda item 6, which is the review of statistics relating to pharmacy technician application denials. I don't know if you remember, but if you attended the July 2014 board meeting, the board members requested further discussions on the basis for denials of pharmacy technician application. Actually, there's a couple applications we'll be talking about, but pharmacy technician application. And the board asked the licensing committee to kind of look at what was causing these denials. In 2014, so just kind of a summary, in 2014, the board denied 45 pharmacy technician applications. Of those applications, 73% qualified by completing the technician training program. 18% of the applicants qualified through the certification by PTCB, and 9% earned an associate degree in pharmacy technology. So the primary reasons for denial was theft, forgery, identification, fraud, multiple DUIs and or combination of other violations, vandalism, disorderly conduct, and obstruction, or drug-related, such as possession or under the influence or selling of drugs. If you look at attachment 4, there is a nice little diagram that shows you the denial trends and which ones are the most common. And for the most part, I believe I read them in the order of how they appear. So theft, forgery was actually 44%. DUIs was 38% of the reasons for denials. Drug-related was 29%, and other offenses such as vandalism, disorderly conduct, obstruction was 33%. And then there's a couple other, including another state that disciplined the individual.
Debbie, of the 45 applicant, but denied 45, how many?
Oh, God, thousands. Probably 9,000, 9, maybe 10,000 applicants.
We only denied 45 out of 10,000
That's all we
applicants?
formally denied, yeah.
Wow, that's a very small percentage.
Are there any other comments by board members?
Well, just a comment. I'm probably wrong on these numbers, but we have about 42,000 licensed pharmacists, that we have licensed under the state board, and about 74,000 pharmacy techs. And it just gets to the whole pharmacy tech issue, the denials and all. And so should there be a discussion someplace in the board, and this is going to be not a bit of a broad brushstroke, but it seems that we have more than twice as many disciplinary issues
Yeah.
with the pharmacy tech category of people as opposed to the pharmacist
I
category.
meant to want to discuss that, yes. I
So-
think we should.
Should we look to raise the qualifications of pharmacy techs for a variety of reasons? One, to maybe, I don't know how to word this appropriately, so I'll just leave it. Should we look to the
Definitely.
possibility of revisiting the qualifications for a person in order to eligibilize them to take?
You
or
just
to
you
get a
just
tech
took the
license?
word out of my mouth, and that's what we want to address today. I mean, we get tired of it. Review those cases over again. It's similar problem. So I always said that they got it so easy. They don't treasure the license. They don't value the license, and seem like the people who want to divert drug, they just keep sending those to get license and then get the drug and leave, and it's so easy. So it's happened too common. So we have to address the issue, and that's today. I really want to put this up.
I mean, I think obviously there's about not quite double the number of technicians and pharmacists.
Right.
So you would expect more technician-type issues. And I think part of the reason I think it was telling in looking at the qualification of the technicians who applied, so 73% qualified through a tech training program, 18% through PTCB, and 9% through the pharmacy degree in pharmacy technology. I would think then maybe our step one is, and I don't know if this is really tedious, but to go back and look at these 45 people and figure out, I mean, obviously most of them come in from the tech training, but maybe we can just make sure that there's not one of those buckets, because maybe they're all coming in through the tech training and none of them are coming in the other way, and so maybe we can go to the tech training group and say, part of your tech training, can you include some sort of, statements about, DUI or, whatever it is. Maybe we can ask them to include in their training that it's not like, Albert said, just a gift given to you. This is something you have to keep. But, Ann, you were going to say something.
I was just going to say that we did actually, to get these stats, we had to
Okay.
pull every file. It was fun. But we did look to see if there were certain programs that, that we could target, like it was one specific training program. And I think that the most we found in a specific training program was 4 individuals. It's a relatively small sample, so I think it's hard to determine at this point whether or not there was a trend there. So we could try to pull another year or two's worth of data. The other thing that we're doing is looking, currently the technician training programs in our law, they just have to meet the 240 hours of theoretical and practical training, and they're not necessarily regulated, or there's not necessarily oversight by the Bureau of Private Post-Secondary Education. I think I said that right. So one of the things that staff is doing is trying to understand a little bit better what the regulation requirements are for private post-secondary. And so we'll be looking at that, and we'll have a better understanding of what those regulation requirements would entail and what that would look like if that's one of the things that. So we are looking at that. We don't have any recommendations at this point, but we are taking it a step further and hope to feed you additional information.
So right now, in order to renew your technician license, you just send in your check, right? There's no pharmacists have CE. There's no CE requirement.
I swear I haven't been arrested or convicted of anything, and a fee. That's all they have to do.
So I'm wondering if maybe, to you guys' point, is maybe either as you apply or as you renew, maybe the easiest way to, because I think to try to target one of these qualifications isn't right or fair. because I think that they all they're all an avenue for different types of people to get into the profession. But what if we had like some sort of a 1 hour program that you had to take either pre-licensure or upon licensure renewal, and it's just kind of almost like a drug awareness?
Well, I've always been a supporter, and maybe not publicly a proponent, but I've always believed strongly, even when I had my own pharmacy company, that it was worthwhile for techs to encourage techs to continue their education. I mean, some techs, dedicated techs, do that. They've been around for a long time. They're very knowledgeable about pharmacy and pharmacy law. Others feel that if it isn't a requirement, they're not going to do it. My feeling has always been that it makes for a better professional if you are continuing your education in that profession during the length of your career. There are groups who are a little resistant to that for economic purposes rather than for educational purposes, and that might be where there is some pushback. But I've always felt, whether I was employing these people or certainly sitting around this table, that looking at the requirements to becoming a tech and continuing the ability for that, and allowing that ability to continue as a licensee, that there should be a higher level of requirement than what I think we currently have. In particular, when we see the function of the tech expanding and the manipulative part of the retail pharmacist or even a hospital pharmacist, diminishing. I mean, as far as manipulations are concerned. I mean, when we look at Kaiser or other large institutions, hospitals, I mean, they go through some rigorous training above and beyond with their techs to ensure the fact that, they've got the education, the experience, and maybe the dedication to be a professional. And I just wonder if that might be something as a licensing committee that would be worthwhile to look at. I hope I phrased that okay.
I couldn't agree with you more. I think you said it. You hit on the nail. As I understand, to become a technician, you don't need to require to go through all those programs. You could just go online and take the test. Is that so?
Yeah.
Yeah. So, I mean, we make it so easy. We should improve those programs that we require certain curriculum for them to go through. Like I say, we just make it too easy, and they don't have some of them really don't have the pharmacy experience, to become a technician. So I think we should concentrate and work a little more on develop some programs that make it a little harder for them to get their license.
Well, and I guess, so I have two thoughts. I understand where you're coming from. Thought number one is we just said, gosh, this is 45 denials out of
73, but go ahead. 73 out of 9,000.
Okay. Well, this said we denied 45 in 2014.
Oh, I'm sorry. I thought there were 73 there. There's actually more than that on the chart.
So 73% looks like.
Pardon me? Oh, sorry.
So we had 45 denials.
I know 73 was the number. Go ahead.
And renewals for technicians are every 2 years. So we have 75,000 technicians, and I guess that's not a good way to, but I'm not sure what the percentage of denials versus applicants is, but it's a very small percent.
But the disciplinary case is very high.
I'm sorry, what'd you say?
The disciplinary case on the technician is very high.
So maybe what we need to do before we jump into something is, so we're kind of focusing at the application. Maybe we need to get information on how many disciplinary cases and kind of more of a breakdown, because we can say that, but we need to have facts before we kind of go charging ahead. Because if it's a very small number of a big, we're kind of solving, I'm not really sure there's a problem. I'm not sure this is really bigger than just normal situation.
I'm sorry. Go ahead, Victor. I'm sorry.
No, Debbie, I totally disagree with you. Okay, there are plenty of statistics to show. If you look at the disciplinary cases that we receive every week, out of 9 cases, only 1 is a pharmacist. The other 8 cases will be all technicians. All right? So take a look at the number of cases that pharmacy technician's license been revoked by the board. You know, you could take a statistic, how many of them. And that's why they're so, like Albert said, it's so easy for them to get into a place. They could steal from the chain store, from independent pharmacy, and it will take us at least 2 to 3 years to prosecute them, to discipline the case. In the meantime, they could still move on to another chain store, move on to another place, to keep stealing for another 3 years before we revoke the license. And even if we did, they would say, so what? I only spent 3 months in that training class school, but I stole for 4 years. They got a money's worth.
So I think let's get some facts, because I think when I think of our 9 cases, I would say about 4 of them are because people don't do anything. And so it gets revoked because they don't act on the paperwork we sent, and half of those people aren't even practicing. So
No.
think
A
we
lot
should-
of these are from theft, from fraud, from
so
criminal
can we
cases
get
that they
some-
had.
I think what we need to do is get some facts, versus us trying to make fact be what we remember in the cases that we've recently.
Let me ask one more question. Let's put the discipline aside, and let's put the denials aside, and just let's look at what the requirements are to become a pharmacy tech, and then look at what the responsibilities are, and in particular, as the profession changes, how much has the tech responsibilities change? Well, now we see tech-to-tech checking for hospitals. But just let's look at what the responsibilities are today, what we expect of a pharmacy tech, and is the requirement to become a pharmacy tech really commensurate with what the expectations are and the responsibilities that they attain as a tech. And I'm just saying, yeah, maybe we have more disciplinary issues, and we probably do, but that's a knee-jerk
But
gut.
there's more
Yeah,
of them.
yeah. But
Right.
aside from that, we're licensing a group that we're requiring very little from. That sometimes the group, a larger percentage of that group than the other groups are problematic. But aside from that, are the requirements to become a pharmacy tech adequate given what responsibilities we expect from them?
So is there a way we can do a review of responsibilities versus, I'm looking towards the staff.
I'm just going to say really quickly, we're kind of off topic. So I think what I would suggest
Thank you.
is that we make this an agenda item
Good.
for a future committee meeting. And in the meantime, staff will look at the different options that we have in terms of what we can do to assess practice, and we'll bring it back to the licensing committee. The one thing that I would like to ask, Laura, tell me if I can or cannot do this. Would you like 3 separate types of discussions, or do you want it all as one, where we're looking comprehensively at the entire program, or do you want to focus just on one piece initially?
I think we should all
But they're-
take the whole look and everything
Well, I
into
think-
one. It's all one.
So-
one
Are you talking about the
discussions.
3 different ways you can apply?
No, I'm talking about looking at it from several places. So we'll be evaluating the duties of a technician and the qualifications, as well as looking at what the causes for denial are, and if there's different pathways that might provide different opportunities for changes, as well as once they've become licensed, what that looks like as well.
I think we want to look at all 3, but I think they are 3 different topics.
But, so if I hear correctly, what I hear as the future agenda item is a review of the pharmacy tech qualifications and requirements. But obviously a factor of that is, what are the requirements? And some of that is going to be driven by some of the enforcement pieces, the statistics that you have available. Or it
Well, I
may
think
be
we're interested
influenced.
in learning about the enforcement statistics to see if that's, if the requirements have anything, if there's any kind of correlation between the 2.
Not only that, like Stan said, as the role expand in the future, they almost like pharmacists, the The only thing that they don't have the signature, that's all. And I think we should have a little more requirement on those, develop a right curriculum for them to fulfill those duties.
Jenny had a question.
ASHP or CP or APHA, one of them is just doing a credentialing program for technicians. Why don't we bring them in and start there and see what they're requiring, why they're requiring it, and what the changes are? Because it's completely different than what they've been doing in the past. So that's one of the things that we can talk about. I think part of it, though, we need to recognize, part of it is the attraction of a technician who is relatively low paid, placed in a pharmacy around a lot of drugs that outside that pharmacy are extraordinarily valuable. And it's no different than a peace officer that's out doing, I just watched a movie over the weekend, and yep, those cops got converted by all the money that they can make by the drugs that they were out enforcing. And so even they were swayed where they've got more in their careers, they've got, they're there to uphold things, and yet they get distorted and brought in simply by the size of the money that they can make. Part of this is the reality of what we deal with. And part of the reason the enforcement committee is looking at hold on to your inventories, count them, control them better, is because the reality is you're working in an area where a single pill can be worth $40 to $50 or $1,000 each out on the street. And that kind of return on investment for just grabbing a container is such that we're going to always have problems regardless. We see pharmacists that are turned by the easy money.
Yeah. I was going to say, it's not just the technician.
But I'm talking about as a public service issue or a public protection issue with regards to the tech and the knowledge of the tech. And I don't want to prolong this, I apologize.
Thank you.
But while we're looking at future agenda items, maybe continuing education.
For the technician, which would be, I mean, we could just make them all do PTCB and stay current with PTCB, because that requires it. But
So
yeah.
that'll be another discussion, but I think it would be a worthwhile one.
All right, so for the public, do you have any comments on application denials? Because we really can't talk about the other things we've been talking about.
We'll agendize them for the next
Yeah,
one.
it'll be on
But
a,
They could recommend perhaps what you
Okay.
might want on your future agenda on this topic.
I know my name is Tony Wong, and I'm speaking as a pharmacist. I know that this, in light of what you just said, Debbie, may be slightly off topic, but just to give my experience, I want to agree with board members Law and Wong and President Weiser in the sense that I think the board needs, it would be good for the board to consider something like continuing education or something like certification or recognition for certain types of skills that the technicians may have, because I really think that really drives the aspirational component of them having that license and, being that professional in the pharmacy profession. And so I think, as an example, for example, I've worked with technicians who know much more about oncology medications than I do. I mean, in terms of preparation and whatnot, as a pharmacist, and that technician, I think it would be a great asset if the board took action to encourage their aspiration purposes, recognition, things like that. And of course, I think that would also have the byproduct of them treasuring their license more and reducing the potential amount of deficiencies and denials. So, thanks.
Thank you.
But on the
public comment?
Debbie, on the future agenda, I would like to see a little more discussion on the requirement and training. I mean, the training or curriculum of those technician training program. I believe they're inadequately trained to become a technician.
And I believe we should also specify on the applications if they have certain problem before that they shouldn't really apply. I mean, if they were registered sex offenders, they've been convicted so many times. I mean, the staff will be taking so much time to check on their background, knowing that the person is already a troubled person. So that is a waste of our time and energy, plus the fact that wasting of their time too for the public. So I think we should specify what requirements or what are the denial facts that they could put in. That way it will save everybody else's time.
Well, and I think, as you know, we did change the pharmacy technician application to reflect, so that it would help guide them to some of the things. And I think we addressed that in the last board meeting. They approved what we had suggested.
I think, I just wanted to say something, because I think, Albert, didn't you bring up too about the schools not checking for, like a lot, I mean, because I'm wondering how we have like 44% with theft and 40% with DUIs. Are the schools checking that before they have them pay to go to school for this tech training?
I believe they are now.
Okay.
Yeah, for a while they didn't, but I believe they run a background because they seem to know the backgrounds of some of these people. Either that or it's self-certification on the part of the applicant.
So bringing that back, so those will be things that would be appropriate for that future agenda item discussion, because right now, your agenda item is a review of the statistics relating to the pharmacy technician application denials. So those are all things that would be appropriate to consider on that future agenda item.
And maybe not just application, it's also discipline.
It's qualifications, but.
Well, I'm talking, so I think we also discussed not
Right.
just the application, but then once they are applied, then also after they are a technician, we also have some discipline issues.
Right, and those things, I think, are, when you look at the qualifications, you're considering those things, because what you're
Okay.
saying is basically in the current screening, maybe you're not catching something. So you'd be reviewing for qualifications, the existing requirements and potential new requirements. Using the pre and post data.
Right. Okay, I'm going to move on to agenda item 7, which is common deficiencies for pharmacy technician application. The board processed 4,449, and so this kind of comes out of that same discussion back in July of 2014. The board processed 4,449 pharmacy technician applications that were received since July 1st, 2014. So just to level set, that would be received since July 1st, 2014 until March 1st, February 1st. March,
Through probably the end of February.
okay. So July 1st, 2014 through the end of February 2015. And during that time period, 4,449 applications were received for pharmacy technicians. Of those processed, 2,392, or 54%, were deficient upon initial review. Over the years, the board has tried various approaches to reduce the deficiency rate, including updating the application form, which is what we've done recently, and I think this is probably about the umpteenth time that that's been done, and instructions to provide more specificity. Regrettably, with these efforts, the deficiency rate still is very high. So just for reference, the most common deficiencies include application is not completed in its entirety, including missing signatures and dates, former names, and things of the such. Training program affidavit, which is required. And it's used to confirm completion of the training program. And the training program affidavit is not completed before the applicant completes the training program, or not being completed in its entirety. So that's being submitted, the person hasn't actually finished the program and they're providing an affidavit, or it just isn't completed, the form's not filled out right. Or the live scan submission, high school diploma, or self-query report is provided under different names, including the also known as on the application, would resolve many of these issues. So in the case of a female, maybe getting married or divorced, the name on the live scan, high school diploma, or the self-query might be different than the name they put on their application, and they forget to say, oh yeah, I'm also known as blah, blah, blah. And as long as blah, blah, blah is a name that's on one of these other reports, then it matches up and we're all good. But if we don't provide that, then that creates a problem. So the board will be developing a fact sheet that will be included as part of the application materials to assist with educating the applicants as they fill out the application. Are there any other comments from the board members on addressing the pharmacy technician application?
Do we actually have one of the real application with instructions so we could review that?
Online, you can get one
Get
there.
it online. So did they fill it online or they have to submit it on the paper?
You can fill it out online, but you need to print it and submit it.
Okay. All right. Well,
That was one thing we lost.
yeah, I was just going to suggest that if that's the case, maybe we need to have more instructions on the side for each items that they need to answer, to clarify and make more suggestions on them.
So what we're doing is we're going to develop a fact sheet, and then we've actually asked our public information officer, who's relatively new to the board, to review it and see if it makes sense to her, because a lot of us are really ingrained because we've been here for so long. So we're asking for fresh eyes to be reviewing it at the same time to see if it's making sense to someone that's maybe not as ingrained in it, to make sure that it would make sense to someone that's, maybe from outside.
And also, you could also review most of the missed questions. If 9 people always miss that part of that means they have questions on that part, then you need to add more clarification on particular questions then, so they won't be silly again.
The only problem is frequently the ones that are less likely to read are the ones that are going to be deficient. And so we've got to find a way to present the questions in a manner where they will respond, and they have to be relatively clear so they don't have to read detailed instructions. We know people don't read instructions.
That too.
So we can try, and that's why we're thinking the public information officer might not be a bad idea, because there it's a way of packaging information or questions in a manner that'll elicit a response, as opposed to, I'll get back to it later. Oh, I'm done. I'll just send it in. So we have real problems with all of our forms on that regard.
Any other comments from the board members? Public? Okay, I'm going to move on to agenda number 8, which is common deficiencies for the pharmacy application. The processing time for pharmacy applications is beyond the desired of less than 60 days. It's currently running about 75 days from receipt. But the staff is working diligent to reduce the processing time. They have also identified a large percent of the applications received are deficient upon submission, which results in further delays in issuing the license. The most common deficiencies for a pharmacy application are: a copy of the approved wholesale credit application is not provided. Quite often the applicants provide an approval letter from the wholesaler, which is not the same as an approved wholesale credit application. The lease is missing information such as the terms of the lease. And a fictitious name statement is not provided when the pharmacy is using a DBA or doing business as. Or the forms are not completed in their entirety. So I guess just going where I'm sure Victor's going to go on this first one, not providing the right letter, is there something in the application that we can put in there to clarify it?
So the application itself indicates that we require the approved credit wholesale application. Can I just say a couple of things? So the first is, this is the first step in us trying to reach out to applicants and let them know what's going on. We'll also be providing a presentation at CPHA on how to fill out the pharmacy applications. We're trying very hard to reduce processing times, but when they're submitted deficient, then it further delays someone securing a license. So that's what we're trying to do. So the instruction sheets, we have tried to be very detailed. I think what happens sometimes is maybe people skip just to the application and don't read the instruction sheet. So understanding that what we've put on there is really what we need a long way to helping. The other thing that's, I think, frustrating for applicants is I think we don't know if the reason that someone didn't provide information is because it's not applicable or they just didn't fill that piece of the form out. So taking the time to review the form, and if it's not applicable, putting a not applicable in so that we know that it's not just missing information. Do you know what I'm saying? So our instruction sheet is, again, something that we're also going to have the public information officer looking at to see if there's a better way for us to be providing the information to the applicants. We sense a lot of frustration right now with the regulated public and applicants because of the processing times right now. So this is one of the ways that we're trying to help applicants is understand from the beginning what the requirements are, what the common deficiencies are, in the hopes that perhaps they can avoid some of those pitfalls. Because what does happen sometimes is we'll do a review, we'll send out a letter indicating information, and then they'll submit the information that was missing, but then that information that we have subsequently received triggers that there's additional information that's missing that we didn't know about because we didn't have the complete packet from the front end. So it leads to a lot of frustration. So we're trying to do some education to really reduce some of the frustration.
And when they submit application, usually you tell them a certain time before you guys respond to them, right? And then once they correct the mistake, you guys put another, I mean, you continue process, or you make them wait another length of time before you respond to them again?
So we're working in both areas to reduce the processing times. Once the mail comes in, once the deficient items comes in, there is additional time before staff get to that to review it. I believe that's...
But it's not put another 60 days before you guys start looking at it. You guys look at it right away, right?
It's not right away, Albert. It's probably about 3 to 4 weeks right now.
It's running 35 days.
Yeah. So I think that's where the frustration is. Yeah.
Absolutely understand. Absolutely understand. And that's why we're hoping if we do some education at the front end and we get the applications in complete, that will help reduce some of the frustration.
It's very hard. I mean, we open so many pharmacies, and each time we go through it, and it's a long process. So we experience ourselves.
Well, it's actually, we know who you are in the sense that we've already got a license issued to you. So that actually sometimes becomes a little easier. But part of the problem we're getting now is that the structure of who owns a pharmacy has changed dramatically. It used to be a sole proprietor that owned the pharmacy. Not a partnership, although sometimes a partnership, but pretty much a human being would own the pharmacy. Now we have layers upon layers of limited liability companies going up. And our requirement is we go to the very top. We have had, we are finding real complex structures. People refuse to give us information. We're ending up with a lot of international folks that don't qualify because they don't have certain kinds of identification that we need in order to know who they are. But just the LLCs themselves are comprised of additional LLCs. So you're building this thing up and up and up. And so when you turn in an application with a relatively, I'm just running a pharmacy, I only need to go one level up, you're already got a deficient app because that one level up is comprised of other entities that we're now going to have to fingerprint and find out who's who and then keep going all the way up. And once in a while, and we've got a whole bunch of attorneys that represent our applicants, we've actually had cases where they refuse to tell us who owns the pharmacy. That app doesn't get processed. But it goes on and on and on, and so part of it we can't always tell you at the front end with generalized directions what you have to submit. Sometimes we have to get the information back, and then we keep going up.
Would it help if we have some kind of orientation for those applicants? You know,
We're going to try that.
Yeah.
So at CPHA's meeting later this week, we're going to be giving a presentation on that. And then if it lends itself, that's perhaps something that we could add on to our website as well as a video for people to watch, as long as Jenny's on video, not me.
Yeah, I think that would be a great idea if you could videotape it and just make it a link. Yeah.
We'll give you makeup and all that stuff.
Fluff up my hair here first, despite the
Or
rain.
can we put on the website that those frequently omitted information so they could learn from other people's mistake?
Yeah, we're trying to work towards that too. And in fact, usually when I do presentations, particularly at the major association meetings, that and our enforcement program are the two things that they ask the most questions about, because it affects their livelihood. It makes sense.
Yeah.
But no, it's taking us too long to process, and we're continuing to have production meetings to get the closure time down again. But part of it's also the function that we're not getting a simple, straightforward application where everything's already laid out. We have to literally do analytical work and sometimes legal work in order to wade through the levels. And we're seeing a lot of hidden ownership. I don't know what that means, but we're seeing hidden ownership.
Are there any other comments from board members?
Yeah, I think the video on the web for new application orientation would be more important, because if you already belong to CPHA or if you're going to the exchange, these are already very concerned pharmacists already. And those are not the ones who are going to make the mistake. I would say the other 80% of the people who didn't belong to anybody, those are the ones who are going to end up making all the mistakes.
Probably, yeah, because they're more connected if they're going to the
Yeah.
association meetings, yeah.
Any other comments? Public, are there any comments about the pharmacy application? Welcome. Make sure you state your name. We would like for you to state your name.
Yes, we prefer you state your name. Not
Prefer,
required
okay.
to.
Megan Maddox with the California Pharmacists Association. I just had a question for the board. So if we do get members who are calling, because I know we had a few instances last year with the lengthy application processing, what is the best time frame that we should suggest to our members in terms of how long it will be? I mean, is there at least a...
If it's more than 60 days, they should probably be hearing from us, although right now we're at 72, so it's pretty close.
72.
What that means is they won't necessarily be licensed, but they should get a deficiency. But anybody that's sitting right around 75 days and hasn't heard from us, have them call me. That's part of my job.
Okay.
And just, they shouldn't be the least bit No, it's fine. That's why I'm there, is to find out when there's a problem.
Okay.
So, and I don't want people to wait 90 days. I don't want them to wait 160 days. I want to make sure that we do what we can, and sometimes they do get lost. We have a lot of applications, and we had new staff. They're not new anymore.
Right.
So if your applicants are calling you, you need to solve the problem by giving them to us, because we
Yeah.
need to make sure that we can get them through the process.
Yeah, yeah. And so there isn't a specific department then, it's...
Oh, there is, but I want to make sure I know what's going on, because if your members are having problems to the degree they're calling the association,
Right.
I need to know what's going on.
Perfect. Perfect. Well, thank you. I think our members will definitely be looking forward to the education, and we'd be happy to help out in terms of distilling that information on our website too.
Well, it sounds like
So-
you guys have already been a big help by letting us speak at the annual
Yeah,
Western.
we're looking forward to this, actually.
Exchange.
I
Western
know,
Exchange.
there's lots of Board of Pharmacy sessions.
There are certainly lots of Board of Pharmacy sessions.
Thank you.
Any other public comment? Okay, I'm going to move on to agenda item 9, which is licensing statistics. And these are statistics for July 1st, 2014 through February 28th, 2015, which is probably the same time period that I was asking about before, right? So as of February 28th, 2015, the board has 141,998 total licensees. And this is made up of 45,255 pharmacists, 74,409 pharmacy technicians, 7,334 pharmacies, hospitals, and exempt hospitals. So this does not include like wholesalers or the 3PLs.
No 3PL, yeah, we don't have the 3PL part.
During the first 8 months of the fiscal year, the board has issued 10,559 licenses, made up of 1,586 pharmacists, 1,963 interns, 5,452 pharmacy technicians, and 1,151 pharmacy licenses.
That's not all that we've issued. Those are the biggest groups that comprise the 10,000.
Okay. I should have said the word including instead of. Yeah. And if you go to attachment 5, is an attachment with all the statistics. And we're going to go through this line by line.
Good.
So 1A, no, I'm kidding. So if you want to, look at any kind of detail, it's provided great detail.
I have
Any
I have a
board
I have a
comments?
question. On January 2015, we have 7,000 pharmacy license. But then you look at February, we only have 6,600. So it's a 500 difference on the pharmacy license.
There was a large chain buyout, and the way that our system is structured, that the timing of the change of ownership was between months. So you have to issue the license one day and then cancel following that. So it was a system error, and it was really just a question of when the change of ownership occurred. That's why there's the spike, the 1 month.
Oh, I was wondering what happened to that 500 pharmacies.
They misbehaved.
Victor-
It was one of those administrative deletions.
Okay.
Any other questions or comments by board members?
I would have a comment.
Okay.
I think, as a board, we just have to be realistic when we see big hits like this, when the chain comes in, buying another chain out, or there's some consolidation. I mean, suddenly the staff is confronted with these, huge jobs that are very time sensitive. I mean, and so, we should try to get as close to what we budget as far as turnaround time for licenses, et cetera. But we have to be realistic sometimes when we ask questions or don't make demands, but have expectations that there are, it's just like the day in filling a prescription. There are times when you're incredibly busy, and then there's a time when you have a little more free time. But to, suddenly be confronted with a large chain that is doing some purchasing or consolidation, it's very, very a huge amount of work that the board staff has to do in a relatively short period of time, and so that tends, I would imagine, to cause priorities to take place, whether they're realistic or not, or expected or not. But I would imagine that's a reality that the staff has to deal with.
As I said before, we have fast track on the freeway. Why can't we have fast track in the pharmacy board? And maybe we could charge them a little extra and then hire extra people to handle the higher low. Is that workable?
Well, we need to go to the legislature to do that. One of the things that actually helps us a little bit is if there's a change of ownership, such as in the chains. And we had 2 chains sell relatively quickly at Christmas, one of whom gave us.
And I'm sure they want to pay higher.
Less than 1 week to process the whole stores, which would be bad enough, except our computer systems are pretty antiquated, which one at a time, you can't do mass. This is not automation in the true sense. So, and then that particular chain, which will go nameless, gave us wrong ownership information partway through the process. Everything that had been processed had to start over again. And so, again, that didn't help. But we were able to issue temporary permits in this case because it was a change of ownership. So that allowed us to ensure that the company could literally, because on the day that we hit go, otherwise they wouldn't have been able to operate. And that would have been a problem. And this was a very visible buyout. We had a second buyout, and we've got 2 more that are getting ready to roll out. 2 more chains are changing. And so it's that staff workload that comes in as a surge, like Monday morning in the flu season for you guys. So it's just something we have to deal with. And the advantage of dealing with the chains, frankly, is we've got a single owner. We know pretty much who they are, and once that ownership gets structured and vetted out, it's straightforward. And then the stores, the greatest problem is you got to look at the lease, you got to look at the PIC and make sure the PIC isn't in trouble. But absent that, those are relatively straightforward, except for the 45 minutes it takes to enter them into the computer and convert one and put one down, as Victor caught, and bring one up. And the system doesn't allow you to do them both at the same time. It's just really frustrating. But the expedite might help a little bit on somebody where we don't know anything about you, but we're going to be a little reluctant if we don't know who you are anyway. But when I said that we know who you are, we've got on file for you, you have 2 pharmacies. So if you add a third, presumably the first thing we do, and I don't know this because I don't process apps, is we look at your current ownership structure to make sure that what we have on file for you is what you just turned in. Surprisingly, more often than not, you will have a couple of different corporate officers or something else will have changed, which now requires us not just to process your one, but to go back and pull your other 2 and get you all straightened out at once. And each one of those is an additional workload. But again, if we don't know you, we're not sure we're going to give you a permit faster anyway, though, Albert, because we don't know who we're dealing with. We know we're dealing a lot of times now with fraud. And we're working with a number of other agencies that are involved in this area dealing with fraud because there's a lot of money to be made if you come in short term, open a pharmacy, and then you go out 6 months to a year later. And
But do you have the flexibility to hire more staff, when it's heavy or low?
no, because in order to get them trained, you don't want to lose trained staff. So the process is relatively complex. You don't need your basic clerks. You need analysts to review the applications. So if we got a sudden surge, the best thing we could do is hopefully find retired annuitants to bring back that are knowledgeable and know how to run the system. That would be an ideal world. It's hard to hire a retired annuitant these days because they're taking the place of regular civil servants, so that's frowned upon. So there's a limit to what we can do. But you're right. I would love, nothing would give me greater pleasure than to be able, okay, we've got an 800-store chain that's about to change. Let's hire 2 or 3 temporary people to do this. That would be wonderful. The state system doesn't make that very easy to do. But I know you want to do the expedited apps. Other states, Oklahoma just called me the other day, and they contacted a couple of other states to see if we had an expedited app. The other 2 states that they contacted beside me both said, we're hesitant to go to the legislature, frankly, and explain why we can't process everybody fast enough. Why should they pay a premium? And that would be very much an argument we would have to be prepared to discuss.
I'm sure the chain in those situations be glad to pay a little extra.
They want to pay extra?
California, I think maybe the legislature might understand, but I don't know.
I don't know. We'll find out. We're going through sunset next year, so we'll have a sense of where we're going, and that may be one of the issues we want to
The
bring
one
up.
thing I do want to mention is it looks like on the back table might be some additional statistics if you're interested in.
They weren't ready for prime time when the packet went out last week.
So they're responding to status requests and updates of licensing programs. So if you're interested in those statistics, I think these sheets are on the back table. Any other comments from board members?
Oh, I'm surprised to see we only have 2 licenses for the centralized hospital packaging. Wasn't that a big thing one time we were talking about the change in the regulations? And so only 2 people just want to get the license? I mean,
Well, there's a statutory change pending, too, to deal with the barcode issue so that they don't have to come in and request waivers. There's a lot of accoutrements that go with that particular license, and we're still having a little bit of problem with the consolidated license. Our law requires it to be part of the consolidated license of the Department of Public Health. But the Department of Public Health never puts a pharmacy on their consolidated license. They just assume it's an integral part of the structure. So if there is one of these packaging pharmacies that's not within the perimeter of the consolidated license, they don't qualify. And we have 2 of those right now that I'm not sure how we're going to deal with them. Because they know they're outside the zone, we don't know how to deal with them because the law doesn't allow for what they want to do. But yeah, we think that the centralized packaging pharmacies aren't being used enough either.
But I'm surprised to see we do have 800 of the steroid compounding pharmacy license that we have.
Yes, and they
In
were
the
all,
state.
that was all since last July, right?
3 months, pretty much, 3-month period, yeah.
Yeah. So imagine the amount of work that the inspector got to go through to license this 800
was brutal.
pharmacies.
Well, I think also the, here, the staff, because I think that kind of put them behind on some of the other. Oh, does that mean it's time to be done with this? Are there any other comments? I think Albert's saying no more. Any other comments by board members?
I try to enter the future meeting day.
Any public members?
Definitely
Any
saying something.
public comments? Okay, moving on to agenda item 10. We have 2 future committee meeting dates. One is on July 17th, and I believe this sheet of paper is also on the back table.
Back table?
Yes, June 17th, 2015, right here.
June, not July.
Did I say July? Okay, June 17th, 2015, right here in this room. And then September 10th, 2015, right here in this room, will be the future licensing committee meetings. And I think we have some interesting agenda topics coming up. So all 6 of you, 5 of you, we expect to be here. I'm sorry?
September 10th.
September
September
10th.
10th.
You know, I think, look on your, just right under, Cheryl, look, did you have both these papers at your desk?
Laura must have it.
Okay. So with no comments from the public, is now the time for public comment for items not on the agenda that you would like for us to consider for future agenda meetings. Please note that we cannot discuss or take action on anything you say, but we would be happy to accept your comment if you have a future agenda item. So public? No?
No.
Okay, with that, the meeting is adjourned. Thank you for attending.
A motion to adjourn? No.